Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Stephen Pateco, and I'm presenting today with James Basilla from our Philadelphia office. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your businesses. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website at www.wglaw.com. And you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is Come On Down, the Price is Right, settling your workers' compensation case for the best value. Next month, our topic will be Section 20s, when and how to get them. So let's get started. The topic today is settling Pennsylvania workers' compensation cases. Other states have different rules and procedures. Today's focus is on Pennsylvania. I don't think I have to explain the advantage of settlements, but just briefly, this is the primary way you can control claim exposure. You can eliminate the expenses of ongoing claim administration and/or litigation. You can avoid runaway claims by settling. Two things I would like to add to this page are avoiding the uncertainty of litigation and achieving finality. There are very few means under the Pennsylvania system to conclude a claim with finality. Even a final decision is subject to being opened up. For those old enough to remember final receipts, even those were not final. So the means of achieving a closed claim with finality, ending all expenses, all further activity, is a full compromise and release settlement. Now, assuming you agree, settlements are a worthy goal for most, if not all, workers' compensation claims. Let's see how we get there. I've outlined several steps to achieve a workers' compensation settlement. And it begins with an analysis of settlement value. The next step would be negotiation, then mediation, and the settlement approval process itself. In terms of the analysis, I break that down into three categories: exposure determination, rehabilitation prospects, and litigation prospects. A review of those three categories will help you determine the settlement value and the pluses and minuses of proceeding with settlement. Now, this just provides really a conceptual framework for analyzing a claim and determining what the settlement value is. There are numerous factors that have to be taken into account that will both add to settlement value or detract from settlement value. Awareness of all those factors is very important. So you want to develop a conceptual approach to the issue. Also, in doing that, it will help you understand the value of a claim and feel more secure in your position, particularly as it comes to negotiation. The more you know about the process and the pluses and minuses, the better you are able to support the position you take in settlement negotiations. Now I'm going to turn to my colleague, James, to begin to address the settlement value analysis, starting with exposure analysis.
Thank you, Steve. So Steve mentioned one key word here is exposure. When you're trying to come to a value of what you think your case is worth and what you think it might settle for, you have to consider the different types of exposures you have on your file. And in Pennsylvania workers' comp, there's different types of benefits that are payable or potentially payable to a claimant. And while there are disfigurement benefits, there are benefits for loss of use or loss of a limb. The primary exposures we see on a day-to-day basis in claims is the exposure on medical benefits and the exposure on wage loss benefits. And we've set forth on our slide here a number of factors to consider. And when considering these factors, each factor, a slight change in the analysis can impact the different types of exposure you have out there. At the top of the analysis here, we have listed a general question of what type of claim are you dealing with. You need to take a look and see what is the status of the claim? Is this something that is denied or disputed, or have you already accepted liability for a compensable work injury? Whether or not the claim is accepted, that should, in theory, change the value, because when a claim is disputed, there is some risk and doubt as to the compensability, and where there's doubt, the value should be less. One of the key factors to consider is the nature of the injury you're dealing with. How severe is that injury? Are we dealing with an injury that is less severe, that seems to be a possible self-resolving contusion or sprain, or are we dealing with a known injury that's already required 1 or 2 surgeries and there seems no potential for full recovery? Obviously, the lesser injuries, they require less in terms of medical treatment and expenses, and the more severe injuries might require a lot more to be expended on the claim in terms of medical and wage loss exposure. One of the other things to consider about your injury is the degree of impairment it actually causes. In Pennsylvania, wage loss benefits are dependent upon the degree of impairment and how that relates back to the time of injury employment. You could have an office worker who has a laceration or a cut on the hand, and he or she could be perfectly capable of performing the job. On the other hand, you could have someone such as a construction worker with a severe back injury who can't do the lifting that might be required on the day-to-day basis of the job. And so the nature of the injury and whether that causes an impairment contributes to the amount of wage loss exposure you could be looking at. Steve, is there anything else you wanted to add onto that part of the
I just want to build on that. It is the economic impact of the injury that creates the compensable situation, not necessarily the injury itself. 2 people with the same exact injury, one could have no economic impact and the other one could have a severe economic impact. Just to give you another example, a surgeon who has a finger injury or a couple fingers, either amputated or severely injured, might be prevented from participating in his profession because of that injury. Another worker with the same exact injury might still be able to perform the duties of their job. For example, a truck driver may be able to drive a truck with the same type of injury. So it's not the injury itself, but it's the economic impact. And as James pointed out, the injury analysis is important because you really need to understand whether it's a permanent injury or one that is likely to resolve, because that will affect, again, the economic impact. And that will move us into our next topic, which is disability compensation rate. This is a primary yardstick to measure the value of a claim. Pennsylvania, being a wage loss state, measures everything in terms of the impact on your ability to earn what you did before the injury. So the average weekly wage is established by formulas at the time of the injury. That becomes the jumping off point for all claim analysis. To the extent the employee's injury prevents them from earning that average weekly wage, or only earning a portion of that average weekly wage, that creates the measuring criteria for the compensation they will be paid. Inability to perform any work would be total disability, and that's generally paid at 2/3 of the pre-injury wage, subject to certain caps and limitations. If the employee has partial earnings, the employee is entitled to 2/3 of the wage loss. For example, if the employee is earning $600 a week pre-injury, their post-injury compensation rate might be $400. But if they were able to work post-injury at a $300 per week job, their wage loss is only $300, and their compensation rate would only be $200. So this becomes very important to the settlement analysis. The other thing to keep in mind, once your disability rate is set, you want to consider all potential offsets. Beginning with the latest round of amendments, our Workers' Compensation Act provided for offsets of the disability compensation rate by other benefits the employee receives. For instance, post-injury unemployment compensation is a direct offset against the workers' compensation disability benefits. post-injury severance benefits paid by the employer. Again, work as an offset and reduce the disability compensation owed. Further downstream, pension benefits paid by the employer that's also responsible for the disability benefits works another offset. And lastly, the Social Security old age benefits, not disability benefits, works a partial offset, again, affecting the exposure for ongoing disability benefits. So that's the disability side of the equation. Knowing your rate, knowing the duration of the disability, knowing whether there are potential offsets and potential factors that would create a partial disability situation gives you your first exposure determination to make. And I'm going to turn it back to James now to explore the expense side of the equation.
And before we get to expense, Steve, I just also wanted to mention one good thing to check for is what benefits have already been paid. For example, if you have a denied claim where you haven't paid indemnity benefits, but the employer did continue salary, then there's a period of wage loss that is no longer an issue if they've already been compensated for their time.
Good point, James. And also keep in mind if short-term or long-term disability benefits have been paid, you might want to take a look at that as a potential offset as well.
In terms of your medical expense projection, again, tying into this theme of how severe is the injury, what you really need to do is take a look and see if you're going to settle a case for a certain value, what is the value of the medical aspect or portion of the claim? What further treatment might the worker require for this injury? If you're in a termination petition, you're litigating a full recovery, arguably the worker doesn't need any more further medical treatment. One thing to consider is if you've already received a settlement demand from the claimant, has any specific treatment or payment of specific treatment been demanded as part of the settlement, which does come with some settlement demands. This can show some interest on the worker's part of trying to pursue certain treatment which they actually feel that they continue to need. Another thing to consider is whether you have any opinions from an independent physician or a treating physician as to further treatment that has already been recommended as to pursue for the injury. One of the other things to consider is whether you have on file any utilization review determinations where some treatment has already been found to be unreasonable or unnecessary at this point in time. These are all factors to consider in what you could potentially be paying out if the worker were to continue to treat and you were not to settle the medical portion of the claim.
James had to say about medical expense projections. These days, we find sometimes medical expenses in our comp claims outweigh the indemnity expense, sometimes by a great amount. We're living in the days of high opioid medications, and that has to be accounted for. There are methods to control that, as James alluded to, but the medical expense can be a very significant portion of the settlement. An accurate projection for those expenses going forward is sometimes necessary, and even if it's disputed and there are means to control it, it has to be accounted for in the settlement analysis process. Now, we're moving on to the rehabilitation prospects. That was one of the primary components of determining settlement value. You know what your exposure is. Now you have to decide whether there's means to improve that exposure, or at least argue that you could improve that exposure. So with medical, as James referred to earlier, you have to do an analysis of your injury, whether that's a temporary or permanent injury, what kind of medical investment and treatment would yield a good outcome. Maybe surgery is necessary to remedy a condition and bring the employee back to work status. Maybe a round of therapy, maybe something else. You have to determine whether to undertake that to improve the claim outcome or project that into a settlement that the employee might pursue on their own later. I want to focus more now on the rehabilitation of the disability side of the equation. Normally, again, because Pennsylvania is a wage loss state, that would take the form of some sort of vocational rehabilitation, if not a job offer by the original employer. Bear in mind, Pennsylvania is always measuring post-injury earning capacity versus pre-injury earning capacity. If the employer can bring the employee back to work in the original employer with an alternative or light-duty job, that's usually the best evidence of an earning capacity, most credible evidence that judges see. If that's an impossibility, and there may be many reasons for it, the next step would be to consider outside job placement. We have now available under our Act labor market surveys where an expert can view the field and determine, based upon a vocational interviews, transferable skills analysis, whether the employee can engage in work out there generally, and in that way establish a earning capacity, earning power, which then becomes an argument to reduce the indemnity benefit payout. Whether that is actually done with full litigation to conclusion, or the process is started and the other side recognizes there's an argument there, it does have an effect on settlement value. It often brings the parties to the bargaining table. So with that in mind, I'll mention two more possibilities. In the vocational rehabilitation field, again, with the emphasis on trying to develop an earning capacity. Funded employment has been utilized in certain cases under certain conditions in the past. That's still available. Now that we are in the post-PROT stage, where the impairment rating evaluation process is no longer available, we think there will be greater emphasis on these other means of establishing a earning capacity. The old form of Kaczynski job referrals, that existed before the amendments bringing labor market surveys into the process. That's still available and might be appropriate under certain circumstances. Again, always trying to prove the employee has an earning capacity, which will reduce the indemnity payout, which will reduce the settlement value. There are barriers in the rehabilitation process that must be kept in mind. This will tell you whether you have a good or bad case for rehabilitation. I'll just mention some of these briefly. The employee may have a few transferable skills. That would impair the ability to prove another earning capacity. The employee might be of advanced age, difficult to place in alternative employment. There might be language issue. The difficulties in placing the employee in alternative employment weigh against a good earning capacity evaluation. Lack of transportation, union status that prevents transferring to another setting could be a problem as well. The effect of other benefits that the employee may be entitled to may make them very reluctant to participate in alternative placement. If they have a third-party case, going back to work may affect a third-party case. You may find resistance there. If they're on Social Security disability benefits, private disability benefits, they may be reluctant to engage. But all these things should be taken into account as you assess your prospect for rehabilitating the claim and lowering settlement value. Now let me turn it back over to James to discuss litigation prospects, one of the other main components that affect settlement value.
Thank you, Steve. One of the first questions is whether there is a litigation prospect. You might have a claim, but you might have no legal basis to proceed with filing a petition, whether it be a termination petition, a suspension petition, or a modification petition. Sometimes when you get stuck with these compensable claims, it seems that the claimants might seem content just remaining on an ongoing payment status, and the question becomes, what can you do to move things forward towards hopefully closing that file? But first, you need a basis to proceed. If you don't have a legal basis to proceed, such as a full recovery opinion or a work release followed by a notice of ability to return to work followed by a job offer, if you have no legal basis to proceed, you do face the risk of unreasonable contest attorney's fees, which is a cost in and of itself to try and avoid. One of the questions to ask is, if you have filed litigation, what is currently pending and whose petition is it? This affects the burden of proof, and the burden of proof arguably should impact settlement value. one of the questions to ask is, what is the venue like and what is the judge like that you're before if litigation is pending? Every judge is supposed to be impartial, but there are reputations that some judges have to be more claimant-oriented than less claimant-oriented. One of the questions to ask or ask your attorney is, what are the strengths of each party's case? What is the likelihood that you'll proceed with litigation? Are you at the point already in litigation where it seems that there isn't much of a chance of winning this round, and really you're already considering the length of time it'll take to finish the litigation, during which time you'll continue to pay ongoing benefits if supersedious has not been granted? Steve, is there anything else you'd like to add in terms of litigation prospects?
I would. You want to bear in mind that there is sometimes an opportunity cost to a settlement. For instance, if you are successful in certain forms of litigation, termination, modification, suspension petitions, you may have access to the supersedious fund to recover benefits that you were forced to pay by the litigation process that were ultimately deemed unwarranted. You will be, for the most part, giving up that ability to make a recovery from the fund in a settlement. So you want to be aware of that as a factor as well. Is it worth proceeding with the litigation for the chance you might make that recovery? Or are you willing to give that up? And if so, how valuable of a right is that? Also bear in mind subrogation. An employer who is paying benefits for an injury caused by a third party has a subrogation right against any recovery from that third party. So this may sometimes become a nice bargaining chip for the employer in the settlement process, because that has some value to a claimant for the employer to waive or modify a subrogation right. It will increase claimant's recovery from the third party, and that can be factored into the settlement evaluation. So I think we'll move on now to the last item on this list anyway, which is Medicare obligations. Very important part of settlement consideration these days, since Medicare became much more aggressive in enforcing their rights. Essentially, Medicare has an interest in making sure that anything that they've paid that should have been paid by the primary insurer, in this case workers' comp, is recovered by Medicare. And they also have an interest in avoiding cost shifting from the workers' compensation system to Medicare. How is that done? Claim is settled, the employee waives all future workers' compensation medical claims, and then starts submitting bills to Medicare. Well, Medicare can rightly complain, we're paying benefits that should be paid by the workers' compensation carrier. So a number of methods have been devised to avoid that possibility and keep those costs from being shifted to Medicare. These are the way they factor into the workers' compensation case if a claimant is getting close to Medicare eligibility, and there's a number of criteria. Medicare set-aside analysis is often done. Sometimes, under the right circumstances, a formal approval by Medicare of the proposed allocation that covers the future medical claims has to be submitted and approved before you proceed. At other times, an informal analysis and set aside of a portion of the settlement to cover those medical claims will keep you free of any Medicare problems in the future. Again, the goal here is to get a settlement with no comebacks in the future, and taking care of the Medicare obligations and handling them properly. That's a topic that could fill an hour. So we can't give it more than a surface treatment here, but it's a very important consideration in settlement value determination. You want to take it seriously. And with that, we're going to move on to our next slide. Okay, and that would be negotiation. Once you've determined your claim exposure and what you're willing to pay, I think the best way to approach this is determine a maximum reasonable settlement value. You don't have to be guided by claimant's demand. Sometimes they are, in our environment, a little bit outrageous. But the employer insurer should determine what they are willing to pay the most for a claim and then work backwards from there. I'd like, in my own negotiations, to set the tone with an initial offer. Many employers, many insurers, they request a demand from claimants' counsel. I think this is giving them the opportunity to set the tone, and I'd rather be the one kind of in charge of that process. You set the tone early on, and you don't have to deal with bargaining positions that are hundreds of thousands of dollars apart. So when possible, I'd like to make the initial offer based upon our not offering the full value, but based upon our evaluation, not theirs. Obviously, you want to leave room to bargain in making the initial offer, setting your initial position, because it's going to be very important. You know it's not going to be accepted the very first time. There's going to be a bargaining process. Not only do you bargain over the lump sum, but you will bargain over many of the other components as well. During this process of negotiation, it's good to raise all relevant issues and address them early on. You don't want to leave issues aside and find out later on it becomes a problem and it's going to prevent the settlement. So you want to get everything on the table that has to be addressed. Past and future medical expenses. Medical expenses are often in dispute in the utilization review process. You may be approaching a settlement and be ready to agree on a lump sum number, and claimants' counsel drops $50,000 of medical expenses on you that you did not know about. Some of these things can be quite problematic. So if it's not apparent, force the issue. Force the information to be put on the table. We already mentioned Medicare set-aside obligations. That process starts with gathering information about Medicare status, Social Security disability status as early as possible. All pending petitions. These have to be addressed in the negotiations. The Commonwealth Court and the judges all expect that a compromise and release agreement covers all issues. If for any reason a particular petition has to remain open, it has to be addressed in that compromise and release agreement. You do want to recognize the status of pending utilization reviews and provide for them. Either we're going to let this go to decision, or the provider is willing to live with the utilization review outcome, or this provider will negotiate the open claims based upon the status of the UR. Sometimes there's a lot of room for compromise, particularly if the provider has not been successful at the initial UR stage. Lastly, I want to mention resignation and release requirements. Many employers are interested in obtaining a resignation or a resignation statement that says the employee will not reapply to this particular employer. This is rarely a problem. It's almost expected in a workers' compensation litigation where there is an employee not working actively for the employer. They're not giving up much when they resign from employment they at least contend they cannot return to. The more difficult situation is when an employer insists on release beyond the workers' compensation benefits. They want employment claims release. They want a general release. They want something else. That has to be supported by separate consideration. Otherwise, it could affect and invalidate the workers' comp settlement. So we're not going to spend a lot of time on this, but I just wanted to hit those and then turn it back to James to describe the mediation process.
And just to touch upon that resignation release requirement, it is important to make sure that that is an issue that's confirmed at the outset before you begin negotiations, so that you can convey to the other side whether or not this is something you'd require as part of the settlement, because you don't want them claiming after the fact and trying to request something additional as part of the negotiations.
That's a good point. You'd like to see the next slide? Okay.
Here's the next slide. Mediation is not mutually exclusive to negotiation, but just a few things we'll touch upon here with mediation. In Pennsylvania workers' comp, we have a mandatory mediation system. If litigation is pending at a first hearing, the judge will almost always ask whether mediation is futile or whether the case should be put into mandatory mediation. There's a question about strategically whether you want to do a mandatory mediation versus a voluntary mediation, because with a voluntary mediation, you get to choose the mediator, and depending upon the nature of the case, the issues in dispute, the claimant the choice of mediator can make a big difference. A disclosure report is something that a lot of judges require as part of the mediation process, and essentially it's a report that's completed in advance of the mediation where each party has an opportunity to set forth how they view the case and the different pieces of information that are important and that impact settlement value and where the case it might be heading. While disclosure reports are not always mandatory or required, we do recommend that one is completed, as that's your opportunity to shift the mediator before the mediation begins. One of the important things about mediation is that you have to have clear and reasonable settlement authority before going into a mediation. That'll make the mediation the most productive, and it won't offend other parties who spend time and effort trying to prepare for the mediation. It's important to have the mediation date diaried on your calendar, because it's important to ensure that you have somebody available from the employer or the insurance carriers and to participate in the mediation if necessary, even if that means not attending but receiving a phone call to discuss the issues and possibly obtain some information. And if a mediation is successful and you do reach an agreement, one of the important things to do is make sure you have a confirmation of the terms in writing, whether by email or by letter, shortly after or at the end of the mediation, so that there aren't any questions down the road about what really was the nature of the agreement. Steve, is there anything else you'd like to add before we move on?
On that point, I've had judges at certain mediations insist that the parties write down on paper and sign the terms of the settlement before they leave. That's how seriously some judges take this confirmation of terms. And in doing so, you will sometimes address issues that had not been addressed in the mediation process. So the judge will force every category of information to be addressed. That's good, and I want to just reemphasize the participation in mediation conference by the employer or the insurer representative is very, very valuable. Judges love it when employers attend the mediations because they otherwise only hear from claimants and counsel. So it's I find the judges take it much more seriously and find it very useful when employers attend. So with that, we're going to just briefly describe our settlement approval process in Pennsylvania. It consists of, number one, a compromise and release agreement. This is a pre-printed form with various categories of information that must be addressed, again, forcing the parties to hit all the important information that has to be included. We supplement this with our own addenda sometimes. Once you have an agreement that's signed or about to be signed, you proceed with an approval hearing process where the judge hears the testimony of the claimant to make sure or to ensure that they understand what they're doing, what they're getting, what they're giving up, not whether it's a good deal or a bad deal for the claimant, but that they have a full understanding of legal implications. With that, you can expect, at least these days, an approval decision usually circulated within a week. We advise not paying benefits until you have that approval decision in hand with language that says appeal rights are waived. It has been a past practice in many places to pay benefits on a bench order. There are case law decisions saying bench orders are not final. You're at risk if you pay on a bench order. They were used because there was, at that time, some delay in rendering these decisions. Now decisions come out fast enough. The inconvenience caused by a delayed decision doesn't exist anymore, and we pay based on the approval decisions. So with that, I understand there is an opportunity to submit some questions. If we have a little bit of time, we will answer those questions if they're on the screen before we end. And let's see if they came through. This is going to be a test for my old eyes. I'll let James give this one a try.
And the question is, what is the web address to obtain additional materials or handouts regarding today's webinar? Well, that's a good question. Do we have that web address somewhere?
All right, we'll do this very slowly.
And the address is www.wglaw.com/WG-university.
Okay, once again, we'll do that just to make sure everyone has it. www.wglaw.com/WG-University. We want to make sure you all have that. Well, there being no further questions, we want to thank you for attending our webinar. Come on down, the price is right, settling your workers' compensation case for the best value. Our next program will be on October 17th from our New Jersey office, and it is Section 20s, when and how to get them. Our New Jersey attorneys will discuss how Section 20 is the least favored settlement by employees and most judges, as it is a full and final resolution. In order to successfully obtain this type of settlement, you must show some aspect of the claim is contested. The webinar will address the appropriate situations in which to obtain a Section 20 settlement and the advantages of such a settlement. You can learn more about this program and all other Weber-Gallagher events at http://www.wglaw.com/WG University. Thank you once again.
Thank you.